No. That's not the general rule that applies in family law. When you're doing a property division in family law matters, you need to go through a 4-step process. And that process involves firstly looking at what the pool of assets is that's available for division. Then the court will look at the contributions that the parties have made to the creation of that pool of assets. The court will then have a look at the parties' future needs. So to look at what their age is, their health, their capacity to support themselves going forward, their responsibility for the care of their children, and then make some adjustments on that basis. So the 4th step then is to see whether the overall division of property is just and equitable for the partners. So it's not exactly 50%, and it will depend really on all those factors as to what the division would be. Oh, you can, but you would do so at your peril.
Right. Okay.
The only way of getting finality between parties who have separated is to have a final order for property settlement or a binding financial agreement which they have signed and had legal advice about, which separates their assets. Otherwise, if you just do the transfer of the house, you remain sort of vulnerable to a claim by the other party for example, a share of your superannuation at some point in the future. Because both parents have a financial responsibility for their children.
Right.
And that financial responsibility will vary depending on the relative incomes of the mum and dad and the number of nights that the children are, for example, spending with each of their parents once they've separated. So the court or the child support agency will also take into account the responsibilities that you have for other children, perhaps of a different relationship as well. So there's a number of factors that go into the formula to work out the amount of child support that's payable by one parent to another.
Okay.
The general answer would be yes. Superannuation is an asset of the marriage, just like any other asset, and so it's available to be divided between the parties. And what will often happen is there might be an order as part of an overall property settlement that the super of one party is split to the superannuation fund of another party as part of the deal.
Okay. Nice one to finish off with.
It is indeed. Because those assets will, the value of those assets will vary. And a lot of the assets that are available at separation may continue to grow in value post-separation, and the parties haven't actually done anything by way of contribution to the value of that asset post-separation, but the asset is increasing in value based on the contributions that the parties have made before separation.